Good morning, everybody, or it's probably good afternoon. I've got 11 attendees up on my screen. I had hoped that this would be a two-way or multi-conversation, but I think it's one-way traffic from me only. But if you can bring up your Q&A tab and click on that, you can then ask me any questions or tell me whether or not any further attendees are likely to appear. Liz, if you could tell me whether I've got everybody now who's going to attend or whether I should wait a bit longer, that would be really helpful if you can do that on the Q&A tab. Okay, that's helpful then. I will start now. Welcome to you all. I understand we may have some Scottish participants, in which case, great to have you on, but can I just give you a caveat that I know nothing about the Scottish law relating to tree roots, and anything to do with the law that I'm going to deal with will be English and Welsh law. So please bear that in mind. I'm hoping that Liz has provided you all with a document which deals with a number of legal cases since the case of Delaware Mansions and Westminster City Council. I gave that to Liz in advance of this so that we didn't have to spend too much time dealing with law during this talk, and we could concentrate more on the technical side of subsidence claims, which is, I understand, what you want me to talk about more. Can I just mention one thing, though, to add to that document that you have got, and that's to refer to the case of Soloway and Hampshire County Council, Soloway and Hampshire County Council, which is 1981 One Weekly Law Reports, page 1, which is an important case in the background behind Delaware Mansions and the history of the cases prior to Delaware, in that it does state quite clearly that the person responsible for the tree and its maintenance must either know or be in a position where he ought to know of the encroachment of tree roots, and that the encroachment is such as to give rise to a reasonably foreseeable risk that such encroachment will cause damage. So the case put reasonable foreseeability right at the heart of the cause of action in nuisance relating to tree roots. And that's something I'll come back to during this talk. Now, look, please use the Q&A. If you've got any questions as we go along, butt in and raise them, and I will try and keep an eye on that Q&A and answer them as we go along as well. So please don't hold back. This is for your benefit, and I know that we've got a number of different levels of experience of such claims, so it may well be you've got different types of questions to ask, which is absolutely fine. Okay, what is subsidence? Well, it's the downward movement of the subsoil due to shrinkage or other causes, which take the foundations of a building downwards, and that may include the floor slab as well. And that movement is often relative to other parts of the building remaining stable. Subsidence is also to be contrasted with settlement, and settlement usually follows the construction of a property where the ground beneath the foundations and the floor slab is settling down, and you may get a compaction and reduction in volume of the subsoil, causing the floor slab and the foundation to drop. That is not a case similar to the subsidence we're talking about relative to tree roots, where you actually get a shrinking of the subsoil due to the extraction of moisture from that subsoil. So you get a volumetric change, which then causes the foundations and potentially a floor slab, if it's supported by the ground, to drop. The first real question that one has in these kinds of cases is, what is the cause of damage that has been discovered by a householder and which the householder has brought to the attention of their insurer or to the attention of a legal advisor or others? And how does one identify what is the cause? Well, the fact is we are all lay people when it comes to ascertaining the cause of such damage. And so the critical thing is really being able to instruct appropriate expertise to deal with that. And if one first considers the ground on which the building is constructed, you're effectively looking at building surveyors and structural engineers to advise upon the damage that has occurred to the building and also what can be gleaned from that damage. Much can be gleaned from the manner in which cracking occurs as to whether there is subsidence or not. Similarly, one needs to ascertain what is beneath the building and to investigate the ground itself. Some structural engineers may be content to do that, but usually they will bring in geotechnical experts who will dig trial pits, create boreholes from which they can extract material at significant depth. And they should also be able to assess the plasticity of the soil that is underneath the foundations. Now, it's obviously important that any trial pit or other excavation goes below the depth of the foundations, because the critical element of tree root induced subsidence is the fact that you have movement of ground beneath the foundation, because it's at the juncture where the foundations meet the subsoil and the depth below that where you will get tree roots extracting moisture, thereby causing the foundation to drop. The fact that there are tree roots above the bottom of the foundations does not greatly assist, because tree roots at that level may well not have any impact upon the subsoil which is beneath the foundation and which is supporting the foundation. So one's got to get beneath the level of the foundations and a reasonable depth beneath that. The extraction of moisture from the ground causes the ground to become what is usually called desiccated, which is the state of the soil when it has had moisture extracted from it. And if one has got desiccated soil, it's a pretty clear indication that there has been an impact from tree roots and that moisture has been extracted from the soil by those tree roots. So the geotechnical element of the investigation is highly important. The other point, perhaps, to just flag up at this juncture is that the geotechnical expertise can become highly important when one is considering whether or not the ground is likely, following rehydration, to expand and heave the ground. And ground heave is effectively where you have got rehydration and you get a volumetric increase in the ground beneath the foundations, such that the foundations will rise after having been taken downwards by the subsidence. And that becomes an important consideration when one is looking at the kind of remedial measures that might be taken once damage has been discovered. But we'll come back to that in due course. So that deals with kind of expertise. We need to look at the ground. We've also got obviously the building, and I've mentioned the need for either building surveyors or structural engineers to be able to assess the damage, the extent of the damage, and whether or not it indicates any cause for the damage. Likewise, one will need the experience of structural engineer or surveyor to assess the remedial works that may be required and the value of them. So they become quite important once one gets to the stage of assessing loss and damage. What is extremely important is to have a very detailed survey of the building, which clearly documents the damage that has occurred. One quite often has crack surveys where the cracks are identified and where measurements can be taken of those cracks over the course of 1 or 2 years. And that is important. More important still, though, however, is to have a level survey done, because a level survey can allow one over the course of 1 or 2 years to assess the actual levels of the building and where precisely the movement is taking place and the differentiation between levels of movement that are taking place. And in so many instances, one does not have a level survey when considering a case, and it's very important that such a survey is carried out to enable the appropriate information to be provided, and therefore for further assessments to be made as to what is the cause of the movement and what are the appropriate remedial steps to be taken. As most of you are probably well aware, one of the critical identifying factors is whether or not there has been seasonal movement, because it's an inherent part of tree root induced subsidence for there to be seasonal movement, in that during the summer months from spring onwards through to September, you are potentially going to have drying of the soil due to less rainfall. And also you're going to have transpiration in the tree leaves, whereby the leaves allow evaporation of moisture. So moisture is being taken out of the tree is taking the moisture out of the soil, which itself has potentially less water in it than it did during the winter months. Therefore, you get the reduction in moisture in the soil, and you get volumetric change if you have a shrinkable clay subsoil. The presence of a shrinkable clay subsoil is a critical element of identifying the cause of damage, because without a shrinkable clay subsoil, you are not going to get the volumetric change as a result of the removal of moisture from the soil. And therefore, if you do not have a shrinkable clay subsoil on your land, you're a lucky person in many respects, because you can ignore the trees and the potential consequences of having trees in reasonable close proximity to buildings. The converse, though, is that if you are on a shrinkable clay subsoil, then you have got to be alert to the risk of subsidence occurring due to volumetric change where trees are in close proximity to buildings. And local councils and other large bodies should be, and usually are, well aware of those areas on their patch which have shrinkable clay subsoils, and they'll be aware of that as much as anything, because there will probably have been past claims from that particular area which led to investigations and which showed them that there were shrinkable clay subsoils in that area. But they should also know that from the geological maps of the area, and any council should be well aware of the risk of tree root induced subsidence in such areas. And so it's no defense for them to say we did not know that we had shrinkable clay subsoil in a particular area. So I've addressed the ground and the building, and then obviously the other critical factor is the tree. And one has to be able to identify the tree that is causing the abstraction of moisture from the ground, which is causing the subsidence. Because it may well be that there are a number of trees in the area. Some of the trees may be on land owned by the owner of the property itself. And so if the movement is being caused by the owner's own trees, then there's not going to be any claim against anybody else other than their own house insurer. But if the tree which is responsible is on someone else's land, then that owner of the tree is a potential target for a claim in nuisance. So identifying the tree which is responsible is of great significance, and the problem often arises in the context of shrubs, ivy, other things which grow on the owner's land, and where roots of those shrubs and ivy are found underneath the foundations, together with roots from a tree which stands on an adjoining neighbour's land. The critical test is, though, whether the tree which is on the neighbour's land made a material contribution. Doesn't have to be the only contribution, whether it's made a material contribution to the subsidence that has occurred and the damage that has occurred as a result of the subsidence. So in identifying which tree is involved, the first step is to take samples of the roots that are found underneath the foundations, and again I reiterate, underneath the foundations, and to get those tree roots identified for the species of tree or plant from which they come. The next step is to engage the services of an arboriculturalist expert who will be able to identify the type of tree likely to be involved. I mean, if there is no other there are no other trees or other shrubs around, then it may be you don't need to look at trying to identify the tree roots beneath the foundations, and you can simply get an expert to come and say, look, this is an oak tree, it's within a certain distance of the property, it's so many meters high, and as a result of its size and maturity, it is highly likely that the roots under the property are oak tree roots and that they are causing the damage. But obviously, if you can get a tree root sample and have those identified, then it just confirms what you might have been told by your arboriculturalist. But an arboriculturalist is vitally important for expertise which basically involves enabling a court to understand the precise process that is involved and which I've just been discussing this morning. But also they are usually quite good at the structural engineering side to a degree. I'm not saying that you should rely upon them as structural engineers, but if they have real experience of tree root claims, they will have picked up a lot of knowledge about the structural engineering and the geotechnical side of things. So instruction of an arboriculturalist is vitally important. I should say that trying to find good experts in this field is not always easy. During the bulk of my career dealing with these claims, I had used a lot a gentleman called Giles Biddle, who was extremely experienced and knowledgeable, who had a very good background in the engineering side of tree root subsidence, but he has retired. And they do come in different shapes and sizes, as it were. That's both engineers and arboriculturalists. And so you do have to choose your expert with care. Going back to the tree, if I may, we've identified a tree. We need to find out what its species is, what its distance is from the property, what its height is, and its approximate age. One also needs to identify what the past management of the tree has been, whether there has been pruning, pollarding, or whatever. And to some degree, an arboriculturalist will be able to identify what maintenance there has been just from looking at the tree. But if you are a claimant, you're going to be wanting to seek disclosure of documentation held by the owner of the tree as to any maintenance that might have been carried out. A council should have records of its policy in respect of tree root management and the management of trees which are close to properties, and they should have records of any works that have been carried out to the tree with which you're concerned. The future management of the tree is also going to be of importance when obtaining a report from an arboriculturalist, because as you're well aware, there are obviously numerous ways in which you can deal with a tree which might have caused subsidence. Ideally, one's able to control the problem by pruning the tree or by pollarding it and reducing its size. That is not always successful, and it also carries the difficulty with it that the maintenance by pruning or pollarding may not be maintained in the future. We all know the difficulties that councils have with their budgets, and one of the first people to have their budgets cut is the arboricultural section, and it is uncertain. Therefore, you'll often get claimants wanting a tree to be felled so that there's not the ongoing risk to the property. The question then arises, if pruning and pollarding is not appropriate, are there other means of dealing with the problem? Root barriers are one thing that are often bandied about, but in my experience, it's pretty rare that they're ever used, because I don't think the profession generally believes that they are a genuine solution. There is always the risk of tree roots getting around, below and around the tree barrier, or through ducts that might have had to be put through the barrier. So, and they are very expensive to install as well. So the critical option of underpinning a property is not vastly more expensive necessarily, but I mean, it obviously depends upon the particular property with which one is concerned. The price of underpinning obviously causes councils and other tree owners to, in many instances, fell a tree which is posing a potential risk to a property. There may be many instances where you have a very valuable tree from an aesthetic perspective, and there may well be, local demands that a tree is maintained rather than felled. But as I say, keeping a tree can lead to very significant costs for councils, which are not necessarily in a position to bear the cost or to share it with any insurer that they might have. I'm asked here, would I usually get an arboricultural report before an engineer? Yes, I think I would always get an arboricultural report before an engineer if I was making the choice. In particular, my concern, though, would be to get a level survey in place. So if the arboricultural expert did not deal with level surveys, then I might well take the opposite approach and get an engineer, because I think it's critical to get in place that level survey. And also, you could say the same about trying to carry out soil inspections. And generally, it's going to be through the engineer that any geotechnical expert is going to be instructed. So I think it's to some degree it's horses for courses, and I don't think there is a right answer. I mean, obviously the easiest thing for me to say is you should probably get both at the same time, but again, that's a cop-out. So I think you've got to look carefully at the particular type of case that you've got to see whether there is a benefit in getting one before the other or not. Right, let me return to the tree. One of the critical issues always is what type of tree you've got and how far away it is from the property, because there are a number of high-risk tree species such as oak, willow, poplar, eucalyptus, elms, hawthorn as well. They're the high-risk trees. All the other ones are moderate risk. And what is critical is to try and identify what the zone of influence is of the tree with which you're dealing. And we do have tables provided by the NHBC, and also there's a BRE document dealing with this as well, which gives information about the zone of influence of a mature tree of a particular species. So that is a pretty good starting point as to whether or not there is likely to be tree roots extending underneath the foundations of a property which is proximate to a particular tree, a particular species. The difficulty often lies, though, in ascertaining how mature the tree is and how high it is to be able to properly use the tables provided. The other critical factor that one has to bear in mind is that tree roots can grow beyond the zone of influence shown in those tables, so they cannot be taken as a critical guide. They are, however, taken as a reliable guide by building regulations and building control. And so they do provide a basis for the design of foundations, which are used by engineers and architects when designing properties. It raises an interesting argument, which I'll come back to in a while, about reasonable foreseeability. If you, as the owner of a tree on an adjoining property, know that a property has been built in the recent past and is therefore likely to have been built in accordance with building regulations, can you therefore take the view that it's not reasonably foreseeable that there is risk of damage to that building from the tree roots of your tree, on the grounds that the property foundations will have been designed to take account of the presence of your tree, which is proximate to the foundations? And I'll come back to it, as I say, but it's an argument that I have run. And certainly in the one case I did run it, it was not successful. In the judge's view, that one couldn't just accept that foundations had been built in accordance with building regulations, and one has some sympathy with, historical experience of foundations not being built to the depth to which they were meant to be built, in spite of inspections by building control. So the NHBC guide and the BRE document also can be very helpful in assisting us to the critical zone of influence. If you do want a book on this issue, dealing with all the technical aspects, I highly recommend a book by Giles Biddle, who I was referring to earlier, called Tree Root Damage to Buildings. It comes in 2 volumes, and there is a lot of extremely complex stuff, which is way over my head, but a lot of it is extremely valuable and helpful. So I would recommend it. Consideration of the tree itself also leads to a consideration of the steps that can be taken to mitigate the risk of the tree, whether pruning, pollarding, crown reduction, or felling is necessary. And an arboriculturalist is the person to advise you about that. I mean, one of the reasons I do like to have an arboriculturalist on board early is to consider appropriate remedial measures, because particularly if you are a defendant in these cases, there is a real danger that, and one sees this repeatedly in claims, as I'm sure you all have, that the defendant, particularly if they're a counsel, will prevaricate for as long as possible, which is due in some part to just not wanting to accept any potential liability, but also in failing to get to grips with the reality of what the situation is. And ideally, councils, for example, I think should be taking faster decisions, and they should be investigating more quickly than they do. And if the reality is that there is a fairly clear liability in a case, and it's going to take the felling of the tree to stop the damage occurring, then that should be done at an early stage. Now, if the owner of the tree is a council or other significant body, they may well have their own tree officers who are perfectly well equipped to take those kind of decisions. But if they don't have somebody of that caliber within the organization, then an arboriculturalist should be brought in to consider whether the tree should be felled at this juncture to get rid of the problem, so that one can move on and not face a claim for underpinning. Because usually the claim for underpinning arises because there is a future risk of continued movement. If one can remove the risk of continued movement, then underpinning is usually unnecessary, and one can simply deal with aesthetic repair to cracking that has occurred both internally and externally, and the cost is significantly less. I don't advance that as a basis for a theory that we should immediately cut down a tree which is being accused of causing damage. Quite the contrary, because obviously trees do provide a very valuable aesthetic and sustainable background to the areas where people live. So one can't go down that particular route of just chopping everything down that one might want to. But it is a pragmatic step which may have to be taken in a number of cases where pruning is not sufficient, pollarding is not sufficient, and therefore felling is the only alternative to underpinning. A tree may be so valuable that it is a decision taken by the owner of the tree that they prefer to pay the cost of the underpinning and would therefore keep the trees and pay for that underpinning. And that it is a decision for the owner of the tree to make. And in many instances, that decision is governed by the economics rather than anything else. But in the case of Delaware mansions, and the importance of the case of Delaware mansions for us now is that it made it plain that it was necessary for the owner of the damaged property to notify the owner of the tree of the damage that had occurred and of their intention to underpin the property in the absence of the tree being felled. That then gives the owner of the tree the opportunity to consider what to do with the tree. If notice is not given and the owner of the property simply carries on to carry out underpinning work without giving notice, may well lead to the owner of the property not recovering the cost of the underpinning as a result of having failed to give such notice. I mean, there are other cases that follow on from that, which I've mentioned in the document which has been circulated to you. Sorry, I've got another question. Question, how long should you give the owner to address the problem with the tree? Well, the easy answer is sufficient amount of time for them to consider the situation and potentially carry out their own investigations. So that will be a matter of months rather than years or rather than weeks. I would anticipate certainly a minimum of 3 months would be appropriate, but I don't think you can put a specific time on it. It will change from case to case depending upon exactly what kind of tree you're dealing with and depending upon the extent of the damage. Right. Let's move on, if I may, to the issue of foreseeability. Before an owner of a tree can be found liable in nuisance, the risk of damage must have been reasonably foreseeable. Now, that means that the owner of a tree may not appreciate the risk in the normal course of events, but then is told that damage has occurred to a property and that it's believed that the damage is caused by the tree. Now, that notice then gives rise to an obligation on the part of the tree owner to carry out its own investigation and to consider whether or not there is an ongoing risk of damage from the tree in the light of the knowledge that there is damage which has already occurred to the property. So that notification of damage is an important factor when considering whether or not there is a reasonably foreseeable risk of injury or damage. And whereas there may have been no reasonably foreseeable risk before, once the owner knows there's damage, then they are on notice. Whether or not there is a reasonably foreseeable risk of damage primarily arises from the species of tree and the distance of the tree from the property. As I've already indicated, it is dangerous as an owner of a tree to start to think about what kind of foundation the property has, because once one has encroachment of tree roots under a foundation or in the vicinity of a foundation, the courts appear to take the view that the risk is present and needs to be considered if the property is within the kind of distance which might be a problem from that species of tree. So again, I don't think one can simply apply the NHBC guidance. I think one has to appreciate that you can get different trees which extend to different distances. And another factor that is very important, I think, is to understand the nature of the vegetation which is in the vicinity of the tree. So if you have a tree which is underplanted, for example, with Portuguese laurel, and there's an example I might give you later of a case of this nature if we have time. The Portuguese laurel, if not pruned pretty heavily, will of itself extract moisture from the soil. If you extract moisture from the soil in the immediate vicinity of the tree, then the competition for the tree is going to cause the tree to extend its roots further than it otherwise would have done so. So it is important to bear in mind the vegetation which is in the vicinity, as well as the species and distance of the tree from the property, because that is going to, again, influence the decision as to whether or not there's a reasonably foreseeable risk of damage. An experienced tree inspector should be taking into account what, apart from the tree, is in the vicinity and what impact that might have upon the extent of the tree roots. So after causation, reasonable foreseeability is a critical issue. One of the arguments that might arise is a council might say, look, we have never ever had any tree root claims arising out of this area. We did not know as a result that there was shrinkable clay subsoil under this property. And there's no reason why we should have known it, because it doesn't appear on a geological map, if that happens to be the case. Now, that gives an argument for that local council that there wasn't a reasonably foreseeable risk here. So that is the kind of argument which a defendant may be able to utilize, but one has got to be careful in how one approaches this. And again, the example that I've got for you later on just emphasizes that. The other issue, which one must not forget, which follows on from the question of reasonable foreseeability, is to remember that a defendant only has to take reasonable steps, such as is necessary to avoid the damage which is reasonably foreseeable. And it's not often, however, that the reasonable steps argument will be able to be brought into play by a defendant, because usually the steps ultimately are underpinning. I did do a case some years ago of Park and Swindon Borough Council, which dealt with movement to an attached property, one of a pair of cottages which were attached, and one of the cottages was suffering from subsidence due to tree root extraction of moisture. And the difficulty was, when considering what remedial steps could be taken, is that if one underpinned the property, there would then be differential movement between the damaged property and the adjoining property, which would cause further damage and then impact upon the owner of the property further away from the tree, which was in separate ownership. So that was provided its own risk of damage. If then one looked at the alternative of felling the tree, then the evidence was that if you fell the tree, you would have very significant ground heave as a result of the nature of the soil, and that ground heave itself would cause further damage to the property, as indeed would very significant pruning cause ground heave, again causing further damage. As a result of that problem and the inevitability of damage, whatever one did, the court found that the council had taken reasonable steps by effectively doing nothing and saying that they could do nothing, having ascertained what steps could be taken and what the potential consequences of those steps would have been. But that is a pretty unusual case. So usually a defendant is not going to be able to have the benefit of that argument, but it is something that you should bear in mind. On the assumption that a claimant has got past the issues of causation and breach of duty, foreseeability, and reasonable steps, then one gets to the quantum side of it. And obviously one has a need to identify the cost of remedial works to be undertaken. There'll potentially be arguments about betterment that arise. And you've also got to ensure that any claim for general damages which may arise as a result of the poor condition of the property in which the occupiers had to live for a number of years, the potential of having to move out and have alternative accommodation during the execution of remedial works, and there may be other consequential losses that need to be addressed. And most of that will fall within the ambit of an engineer and additional evidence from the claimant as well. Let me just address the issue of third parties, because I know tree preservation orders do cause some issues to arise, usually in the context where the owner of the tree is aware that there is a TPO in place in respect of that tree, and therefore tries to bat away a claim from a claimant by saying, look, there's nothing I can do about it. There is a TPO in place, and therefore I can't do anything to the tree. Therefore, I'm not liable. I'm afraid that argument does not run for a defendant, because the reality is works can be done to a tree which is subject to a TPO if the tree is dying, if it's dead, or if it's become dangerous. Similarly, work can be done to a tree, including felling it, if it's necessary for the prevention or abatement of a nuisance. Now, I should, that from section 198, subsection 6 of the Town and Country Planning Act 1990, and it's addressed in the case of Perrin and Northampton Borough Council, which I've set out at paragraph numbered 6 in the document, which has been circulated to you. And the case of Perrin makes it quite plain that before one gets to the point of being able to carry out any works relying on section 198 subsection 6, one has got to look at every other single opportunity to enable the nuisance to be stopped by other works to the tree or to the environment. So that may include underpinning, or it may include a root barrier, it may include pruning or whatever. But the problem is the problem of the owner of the tree. It's not a problem for the claimant, the person whose house is damaged. So the owner of the tree has got to get any dispensation if that's what they want to do from a council, or that owner has got to make a decision as to whether or not they want to run the risk of felling a tree on the grounds set out in section 198 subsection 6, and the consequences that might flow from that if they'd got it wrong. It's also right to mention there's no right for an owner of damaged property to go onto the property of another to fell the tree without permission. The only thing that the owner of the damaged property can do is can cut roots of the tree which are on his or her land, so they can sever the roots, take them out of the ground. It may lead to some instability of the tree, which they have to be aware of, but it's a step that can potentially be taken. But that really is the only physical step they can take without obtaining permission from the owner of the tree. Last issue I was going to deal with is that of limitation. It's obviously 6 years from the occurrence of damage, albeit that is subject to the secondary limitation period from the date of knowledge under section 14 of the Limitation Act 1980. Limitation is not always a particularly important thing in tree root cases, because tree root induced subsidence is a continuing nuisance until the cause of the subsidence stops. So one is going to have a continuing nuisance all the way through until the tree is felled or work is done to stop the nuisance occurring. So it's important always to bear that in mind, that it's not just when damage first occurs. It's not just when damage first occurs, but it is also continuing so long as damage continues to occur. Now, Liz, do tell me when I should stop, when people have got other things to do. Have we got time for me to deal with an example of a case that raises some of these issues? Can you give me a heads up on the Q&A as to, hold on. Right, okay, thank you. I will deal with it's in fact another case involving Swindon Borough Council called Brown with an E, which does raise quite a lot of interesting points within it, but I'm going to take it reasonably quickly. But it's a good example of a case. I was defending it for Swindon, well, you'll be able to make up your own mind whether we succeeded or not. We didn't succeed in toto, but we got a tolerable result out of it for reasons that will become apparent. Property constructed in 1988. There was a 1.5 meter rise from front to rear on the site. Foundations were constructed, and there was an independent floor slab which supported the internal walls. It turned out the property was built on a high plasticity subsoil. The planning drawings provided for planting, which included a cherry tree and Portuguese laurel. The allegation was that damage occurred to the property as a result of the roots of the cherry tree growing under the property. The damage, or the primary damage, was to the floor slab, which, as I've just said, was unsupported by the external walls and which supported the internal walls. So you had a dropping floor slab which was creating gaps between the top of the floor slab and the bottom of the internal walls, so the bottom of the skirting boards on the internal walls. Swindon Council became responsible for the planted area, which included the cherry tree and the Portuguese laurel, and which ran alongside a highway. So having been built in 1988, by 2007, the floor slab had started to drop. The owner of the property raised the issue with household insurers, who refused to cover the damage to the floor slab in the absence of any damage to the walls. By 2011, the damage had got worse. The cherry tree was 8 meters in height and was standing only 3.4 meters from the house. The planning drawings had shown it at 5.5 meters from the house, so it had actually been planted closer to the house than was originally anticipated. The laurel, the Portuguese laurel, was periodically cut back, but at times had been 7 feet in height at one point. So one can see that it had been allowed to grow unconstrained for significant periods. As I say, the internal damage got worse by 2011, but still there was no visible damage to the external walls. Trial pits were dug in various locations, and a large cherry tree root was discovered growing under the middle of the floor slab. The soil, as I said, was found to be of high plasticity due to the investigations carried out, and also subject to volume change. The council rejected the claim, but did agree to fell the cherry tree. They did nothing about the laurel. It was expected that rehydration would take place, but that it would take place over many years. So that's basically the argument. There were arboriculturalists and engineers on both sides. And the judge ultimately found that the foundations were not as deep as should have been provided with a cherry tree in the location in which it was planted. The foundations on the plans should have been 1.47 meters, but were in fact only 1.3 meters in depth. The council obviously said, well, look, we didn't know that they didn't comply with the drawings which were put through for building control of 1.47 meters depth, and that would have made a big difference. But when we didn't know they were only 1.3 meters, so how could we have foreseen that this tree was going to cause a problem? Well, that, I'm afraid, did not wash with the judge. As I've indicated before, he took the view that if a tree is in close proximity to a property, and as a result of that proximity is likely to have tree roots which may go under the property, then it is the responsibility of the tree owner to carry out investigations to ascertain whether or not that tree is going to cause damage to the property. In fact, in this particular case, the greatest displacement of the floor slab was in the middle of the property and not close to the tree itself. The position was made more difficult in that there was no apparent seasonal movement, such as one normally gets with tree root movement. The judge slightly dismissed that by saying, well, actually, the difficulty of measuring movement where you've got a floor slab drop compared to cracking within the outer walls of a property is that much more difficult, and you might have movements and for them to have gone unseen. Well, I would dispute that, but that was his conclusion. The defendant argued that the cause of the damage was in fact settlement due to a poorly compacted backfill beneath the floor slab, albeit possibly with some contribution from the tree to the downwards tilt of the flank wall nearest to the tree. So that was the wall nearest to the tree. There was some tilt, and a level survey carried out subsequently did in fact reveal that there was some downwards tilt of the flank wall. But as I say, there was no external damage by way of cracking or bowing or anything like that. And the judge found that the proximity of the cherry tree did create a foreseeable risk of damage to the foundations of the nearest external wall. And he found that the cherry tree did cause desiccation to the soil, and that the zone of influence was greater than would normally be anticipated, but roots extending further than normally anticipated, particularly where there is dense underplanting with competitive vegetation, is something that is foreseeable in the judge's view. And he was saying really the underlying vegetation and its risk or involvement in the risk should be recognized and taken into account. The depth of desiccation correlated with the depth of the tree roots at 1.5 meters where they were found. But in this case, there was no drop in shear strength below that depth. And normally where you have desiccation to a certain depth, you are going to get a drop in shear strength in the soil below that desiccated level. That was not present in this case. And there was also limited evidence of recovery following the felling of the tree. And the judge did accept that all of this led to the conclusion that there was another cause of the downward movement of the floor slab at play in this particular case. And he agreed that 70% of the damage was due to settlement of the ground due to inadequate compaction and due to the nature of the soil which had been used to backfill. And only 30% of the movement was caused by tree root activity. The council had carried out reactive pruning, but only did so intermittently, and in fact, no pruning of the tree prior to the complaint of damage had been carried out. And the judge basically said that the tree officer should be able to look at a tree and form a view as to whether it posed a risk. If he decides he needs more information from his own counsel, then he should ask for it. He simply cannot assume that the foundations accorded with the NHBC guidelines and had been correctly inspected by building control. He also said that the absence of damage to external walls was of no relevance, and said the tree officer is not entitled to wait for evidence of damage to walls before he sees a risk due to the proximity of the tree, since if you wait for damage, by then the risk has occurred and it's too late to deal with that risk. So if there is any foresight of damage to a flank wall, then the tree officer should act and engage in a detailed investigation. We argued as defendant that the maintenance of the tree was important for the aesthetic of the area, but basically the judge said that was not important and did not detract from the council's obligation to take steps where there is a foreseeable risk of damage. There was also an issue on limitation in that the claim was brought outside the period of 6 years from when the damage occurred. But in this case, the court did find that the date of the claimant's knowledge was significantly delayed. As I told you before, his insurer had basically denied responsibility under the policy, and so no further investigations have been done by the claimant. So he only latterly became aware that the damage was caused by tree root activity, and the claim was brought within 3 years of him having that knowledge. So the claim came within the secondary limitation period, and the claim was allowed to proceed accordingly. So I'm sorry to rattle through that. You can see it had virtually everything in that case. And it is interesting from that perspective. It also, I'm quite sure a judge could potentially have taken a different view in that case as well. So it shows how finely balanced the outcomes can be. Whether the judge thought he was taking a middle course by ascribing 70% of the damage to another cause or not, I don't know. But it was nonetheless an expensive claim from the council's perspective. That's really all I've got to say. Here's another question, which is an issue that causes me great grief, really. If a tree is very old and a house is built close up to it more recently, is the court less sympathetic towards any damage caused? I think this is a very difficult area and one that has not been resolved. The difficulty lies in the fact that someone who builds a property in close proximity, say, to an ancient oak tree, whose roots are inevitably going to be growing under the footprint of the building that is being built, is a person who is coming to a nuisance, effectively. And if you come to a nuisance, it doesn't provide a defense to the person who creates the nuisance. So on strict principles, the owner of the tree is still potentially liable if one builds on top of the tree roots. Now, having said that, there is a genuinely significant argument, it seems to me, about reasonable foreseeability of if a tree is being built in close proximity to an oak tree, then it is reasonable to assume, I would argue, that the foundations would be sufficient to avoid damage to the building. And really, it's a matter for the structural engineers involved in designing the building. But as I've indicated just now from the case of Brown, one cannot say that that argument is going to succeed. Obviously, there are potential claims against those who designed the building or built the building, but it may well be that limitation has expired in respect of those claims, and that it will be very difficult to take any steps against those individuals. They may have gone bust, they may no longer exist. And I've just, quite recently, I had a case exactly on this ground, and ultimately, it was settled because the council basically took the view that they couldn't really run the risk of going ahead on a case where they couldn't be sure or reasonably sure of the outcome. But it was a very, very old, highly valuable oak tree, and it was felled ultimately, really on economic grounds to save the potential costs of the litigation, which is extremely sad. But I don't see a clear answer to this particular problem. Another question, we often have difficulty obtaining information from councils. Yes, I can understand there can often be a difficulty. I think it's just a question of perseverance, and it's a question of getting a disclosure and, if necessary, making applications for disclosure. But you need to be quite clear what you're asking for, and ultimately you should get it from them. And if they don't provide it, then to some degree you can say, well, look, you've had this opportunity to provide it. We will go ahead with underpinning, and that's your fault. We told you about the risk of underpinning. We told you to get on with it. You haven't done so. We are going to proceed with whatever remedial works we think are appropriate, providing you give them, sufficient notice of that. I don't think there would be a problem. And you can look at the case of Jones against Portsmouth Council, which is quite helpful on that aspect. Here a question: if you cut back encroaching roots and kill the tree, are you liable to the owner? That's a very good question, and I'm not sure I can give you a good answer at this stage. It's not something that I have looked up or considered. I mean, I think if there is inevitably a risk in cutting back encroaching roots, in that A, they're going to grow again, but B, if you do it, you may destabilize the tree. If you destabilize the tree, it may fall and cause further damage to property by falling. And one can see that that may potentially raise problems, albeit I would think there is a perfectly good defense on the part of the person who cut the roots, because it's something they're entitled to do to abate the nuisance. And the solution always lay in the hands of the person who owned the tree, of cutting the tree down. And if they, providing they were informed about the roots being cut, then it should be a matter for them to take steps to consider. But I don't, so far as the law is concerned, you'd have to give me a bit of notice to look that up further, I'm afraid. So I'm sorry, I can't answer that one properly. Karen, you say you don't think it's been resolved by the courts yet, but the issue arises a lot. All right, well, I've given you my views, and I would be inclined to say the owner of the tree is the person who ought to deal with the problem. That would be my initial view anyway. All right, well, I think that's I hope I've answered all the questions. That's the end of the questions. Thank you very much for coming along. I hope I have answered your questions and given you some assistance in dealing with these kind of claims. If you've got any question, do feel free to email me, and I'll be very happy to try and answer some emails, and I might even start looking a bit harder at your question, Karen. Thank you very much indeed. Have a good afternoon, and I'm sorry we can't see each other. I think I would quite like to have done this more as a discussion, and I think there is actually another form of Zoom which we potentially could have used, which would have allowed us to see each other and actually talk to each other. So I'm sorry if we haven't used that and could have done. But cheerio to all of you, and thanks very much for coming.